Hello, I'm Jean Pete, and I welcome you back to our show, Better Living. Better Living is brought to you by the Homestead Hope Foundation and is sponsored by Homestead Hospice, where commitment to education and premier hospice care helps patients and families through life's most important journey. Thank you for joining me again today. Today I am here with two guests. I have Chris Brannen and Paul Black, and they are with the Brannen and Black Law Firm based out of Decatur, Georgia. And they specialize in elder law. We're going to talk today about estate planning, special needs planning, planning for long-term care, anything that you need to know if you or a loved one or you have a relative who is, getting older in life and you're thinking about or maybe struggling with an illness or maybe not, but these things happen. We need to talk to you today and help prepare you and get yourself financially healthy regarding getting your assets together. Is that right, would you say?
It is. And while a lot of our clients are older, that's definitely what drives our practice, working with families of often seniors or disabled people who have had big events. We also do a lot of planning for young families, and that's a really nice balance to be able to work with those families as well.
Yeah, and, the more shows that I do, the more experts that I talk to, we say it all the time, and you do have to prioritize, so not everybody's going to move, but getting yourself ready before the crisis happens, it just helps you live your life that much better.
Absolutely.
We always wait. We procrastinate. We put everything off. But this is such an important topic. So thank you so much for being with me today. So again, I'm here with Chris Brannen and Paul Black. So first I'll introduce you, Paul. If you could just let the audience know a little bit about you and your background and how you got involved with elder law.
Absolutely. So I grew up down in Albany in southwest Georgia, or Albany as we say down there. I got into elder law because both of my parents have big health needs. My mom has had Parkinson's disease for 24 years now, since I was probably 11. My dad had a major stroke at age 53 when I was 22. And being in their lives as a caregiver, as a child, has definitely been one of probably my most defining experience. And when I went back to law school, I knew that was an area that I wanted to practice in.
Did you have to help your parents navigate through all of that while you were that young? So did you have experience with that whole area, or did you just realize I want to do something to help my parents?
I could not. First, I did not know how. And second, I didn't really have the maturity to do so. So A lot of what brought me into this practice area was that kind of a sense of frustration, but also a desire to help others. And I'm happy to say now, after a few years practicing, that I can and do help my parents with all kinds of the issues that pop up. And it's great to be able to do so for other families as well.
I bet. That's interesting. Thank you for sharing.
Absolutely.
And then, Chris, let's talk a little bit about you. How did you get involved with elder law? What's your background?
Sure. Well, I don't have the personal narrative or the personal story that Paul does with elder law, but I started doing more traditional estate planning when I first began practicing law. I enjoy planning and working with people to accomplish goals, but I also wanted to be more specific within that. I've enjoyed, and really, frankly, it may sound corny, but I've always enjoyed working with my older clients. So when I was starting, there were just beginning to emerge this subset of estate planning, which is elder law. And there were a handful in Atlanta that were doing it, and it just appealed to me as both a planning practice and a specific skill set, and a client base that I enjoy working with.
I'm interested to know, and you may not know, I don't know if there's statistics out there, but what % of the population actually has estate planning in place?
There are a lot of numbers we've seen anecdotally. Maybe 60 to 80% of people die with no will or estate plan in place. A will is always the first document people think of, but as Chris and I would remind them, having a durable power of attorney for someone to manage your finances if you can't do so, having an advance directive for health care here in Georgia, which empowers others to make your health care decisions if you can't, those are documents that nearly everybody should have in place, even if they don't need a will.
Yeah, and I'll tell you what, I've worked in home care and hospice for a long, long time, and so many times people are stricken with a health issue. I mean, it could be pancreatic cancer.
Right.
And it's so quick, and there's not a lot of time. And there's no wills, there's no estate plannings, there's no nothing. And then you see infighting with the family because
Right.
no discussions have ever been had. And advance directives, if you do nothing but that, you are giving such a gift to your family. And I always try to tell people, and I'll have doctors on the show, and I'll tell them, listen, I'm going to say it on the air too. Anytime you give a client, a patient, a terminal illness, you need to be talking to them about getting advance directives in place on that first visit, not later. Because what an advance directive is that I'm talking about is, like you said, Paul, is for healthcare decisions. And so often in my work in home care and in hospice, a spouse might appoint their spouse to be their healthcare proxy, the person that would make decisions if they couldn't. And that person's just not capable. They can't let go. They don't want to do it. May be your wish that you don't want to be hooked up to a machine, but they just cannot. And so you really have to have open discussions. And this is a great way, like you said, Chris, you've got to plan. You've got to plan and communicate. You can't wait till the last minute when the crisis is occurring. I guess you can if you have some time, but so much better to communicate with your family members. You're leaving them a gift to keep the peace as well, so that everybody knows what your wishes are. Do you want to talk a little bit more about that?
Yeah, I mean, there's actually a lot to unpack there. One theme that you've hit on already, which is very important, is getting these documents done while you can, and not procrastinating. I mean, let's be honest, doing estate planning or financial planning, particularly when it involves, end of life decisions, is not fun. So people put that off. But there are really two specific kind of urgent reasons to do those now. The first is, the families that we work with, so we see this on a daily basis. They have had some type of, healthcare event or diagnosis that has spurred them into this new sort of reality of care and finances and planning. And capacity is very often an issue for our clients. If they have an Alzheimer's diagnosis or a dementia diagnosis, sometimes they wait too late. With an advance directive for healthcare or a power of attorney, they have to be competent to understand what they're doing. So you lose the ability to make those judgments and to put those documents in place if you're still living, but you're not able to express that or not able to make that decision. The second piece is how expensive, frankly, just long-term care is. Whether you're talking about in-home caregivers, private caregivers coming into the home, whether you're talking about nursing homes, skilled nursing level of care, or assisted communities, it's expensive. The earlier you look at that cost and how it potentially impacts your estate plan and your sort of life expectancy, the better planning options you have. If you wait until the care need is imminent, your planning options are severely restricted. It's still worth your while, even at that time, to sit down with someone and think about how to protect your assets and how to maximize your income. But it's a totally different conversation if you wait till the last minute.
So what's a typical age? Because, midlife, you're still getting kids through college. You're not going to think about it. Right. You're just not. You're going to keep putting it off. What's a typical age someone should come in and talk to you?
Well, to highlight what Chris just said, the earlier the better. Mm-hmm. And for a lot of, Chris and I are both relatively young. We're 35. We do a lot of estate planning for people our age, I would say young couples. And in our world, where our average client is often, in their 70s or beyond, anybody under 50 who walks into our office is going to be a young couple. What we tell them is that because we do so much planning, for people who are having a late life health crisis, we know what the end game looks like financially and planning wise. And our job is to not only help those younger clients get great planning in place, but also foster a lot of the really tough conversations about, the what ifs. And as a very personal example, my mother was diagnosed with early onset Parkinson's at age 41. Wow. My dad had a major stroke again at 53. So those, for better or worse, it's not always been a fun process, but clients do listen when we're able to share those very personal examples and say, a little planning now can save you a lot of uncertainty and your family a lot of frustration down the road. It's not always, as Chris said, most of us by nature are procrastinators. And yet, without exception, when we've done planning for anyone, especially those who are younger or healthier, they always tell us in the end, thank you. We have so much more peace of mind knowing that we have this in place, knowing that, we've had these conversations, and knowing that we can call you and others to meet our needs if anything ever happens.
So let's talk a little bit about that. What kinds of plans do you put in place? Let's start younger. So for someone in their 30s that walks into your office, what are the typical things that you would put in place? And let's talk about a typical cost. Everybody always hates that question because there's nothing, it runs the gamut. But just to help people understand what we're talking about here cost-wise, some kind of an average cost.
Sure. So, interestingly, the structure, kind of the basis of the estate plan doesn't change, whether or not it's a 25-year-old couple expecting their first child or a 95-year-old person who's in a nursing home. The three documents that we recommend our clients have are the Advanced Directive for Healthcare, which you mentioned earlier, the Durable Power of Attorney, and also the will. Sometimes the will is replaced by a revocable living trust.
Yeah, I want to talk about
or
that
some other testamentary document like that. But for a younger couple, so typically the first life event that motivates people to think about their planning is their first child. And so a lot of, Paul and I are both 35. Neither of us have a family yet, but a lot of our friends have started young families. And it's very important when you're expecting your first child or you have your first child to think through your estate plan should something happen to you. So with a young couple, we're talking about the Durable Power of Attorney, the Advanced Directive for Healthcare for both husband and wife, making sure that their spouse usually is appointed as their agent under those documents. So if, something unforeseen happens, they don't have to go to the probate court and deal with guardianship or other issues. The child, in our society, in our legal system, children cannot inherit property, period. So the first thing is if something happens to both parents, we set up a minor trust in the will, which says that, if something happens to both husband and wife, this property passes to our child to be held in trust and used for their benefit until a specific age. That saves a lot of time and a lot of headache of having to go to the probate court and deal with that. You also get to choose the person who manages the money. If you do your will and do your planning, you can appoint the person who is the trustee. And you can also address issues like who gets to raise the child.
And they could oftentimes be different people.
We see about a 50-50 split. And a will, as Chris was saying, is where you can name a testamentary guardian or guardians to care for your children if both spouses are dead. So in addition to that, there's also a document that a lot of estate planning attorneys don't use. It's called the designation of standby guardian. And that document would speak if the wills can't. As most of us know, a will can't speak until the person who wrote that will, the testator, the person who made the will, is dead. What if mom and dad are both still around and yet both incapacitated and they can't serve as parents?
Wow.
That's where a designation of standby guardian will empower someone else to serve, to take care of those minor children for about 4 months. The form says 120 days. If mom and dad are still not able to be parents at that point, then those standby guardians have to petition the probate court to become permanent guardians. So,
gosh, you don't even think about that. That's true. That's so important. Right. A car accident, and head injuries. Right. You're still here, and that could happen.
And you're getting the flavor that a lot of these are tough conversations. And frankly, this is what separates a lot of the elder law and estate planning attorneys from the rest of the profession. You have to be patient, I would say compassionate, to be able to work with families who are often in crisis and to really have these conversations with people who are younger and healthier, but do so in a way that makes it clear that, we introduce the conversation and yet they have to have a lot of conversation in their family about if this happens, who is going to serve, and have we talked to that person about what this means? So it's quite a process for any family to go through. And I actually want to contrast that to if you go onto the internet or elsewhere and you simply get a form. We've seen some really good forms that people have produced on their own. The big loss that we see is that those families who don't go to an attorney to get good planning, they don't have someone who will ask a lot of the tough questions. They don't have someone they can call when something happens. And I don't exaggerate to say that about 10% of what Chris and I do is cleaning up after either documents that people have drafted themselves using, online software, or documents that attorneys have drafted that have been done poorly that create a lot of messes down the road. So we always advise that, you don't have to go see us, but go see someone who specializes in these areas. Make sure they know what they're doing, and expect to pay, a fair price for what you're getting, and expect them to give you a lot of their time and expertise in return. And
so what is a typical cost, just to help folks? I want to motivate them to come and see you, and if we leave it out there without giving them some understanding, they're probably not going to be motivated to move.
Paul and I's goal for our pricing is we try to do everything flat fee. We don't like to bill hourly. We like it to be straightforward and clear from the beginning what it's going to cost. For a young couple that we've been talking about, our flat fee is $1,500.
Okay.
That would be for 2 wills, 2 advanced directives for health care, and 2 durable powers of attorneys.
Okay.
With the caveat being that if you want to do something really complex and outside of the ordinary with your wills, then that may cost a little more.
I like the flat fee too. Now, is that different than most? Is it still an hourly?
There's a trend towards flat fee, and I think it's really growing because nobody likes surprises.
No, the unknown.
$1,500 for Chris and I, and for most families we work with who are younger, that's a lot of money. This is a big investment, and what they get for that, it's not just about the documents. It's also us looking at their entire financial picture, their family dynamics, and making sure that everything is addressed in concert. Down to the beneficiary designations on their life insurance. And if they have any larger family issues, they have a safe space to talk about those dynamics so that we can plan to make sure that if there might be conflict down the road, the right people are in the right roles to make the right decisions.
Mm-hmm.
And the documents, having the documents in place and having them signed is an important first step, but it's not the only step to having your estate plan, become effective. We've been talking about communication. One, going through this process and talking with us about what you want and what your wishes are for your care, hopefully starts that communication process with the family members. And that's, we always stress to our clients, this is great that we have these documents in place. Make sure the people that you've appointed in these important roles are aware of these appointments. They're aware of where the documents are located if they need them. And you have a conversation about your wishes and your expectations.
I love that because I do have a friend whose family has quite a bit of assets, and they're naming their son as the guardian or executor or whatever, and everything is a secret. And it's just causing resentment and turmoil and separation among the siblings. And I think, why does everything have to be a secret? You guys just need to communicate, but they just won't. And do you find that often?
Yes. Okay. Every family has its own dynamics. I've done planning for a lot of very happy families. Chris has as well. We have yet to meet the perfect family where there are no issues. So part of hiring a good estate planning attorney or a good elder law attorney is having a confidential relationship and a safe space where you can say, I can't trust my brother to make these decisions for mom's health care, and here's why. Or I can't trust, my uncle to receive money for benefit of my kids, and here's why.
But you can't do anything about it if your parents...
We absolutely can. The drafting process, and again, one argument in favor of having a real-life person and a specialist is that we can draft to address almost any need you can think of. We do so on a regular basis, and frankly, that is what we are paid for. We're not paid for something that is, just off the block. It's something that's going to be customized to the situation of, that person or that family. And As an example, yesterday morning I met with one family that's about to be worth about $7 million after an inheritance. My client that morning has a net worth, before them of $235. So wow. Chris and I see a huge range, of people who come in and who need planning. We can only do so much pro bono, but our typical clients are ordinary, middle-class folks. A lot of our younger clients, they don't have a lot of assets.
Right.
And that's okay because we can help them determine how to use life insurance, how to get the right disability insurance policies in place in conjunction with their financial planner if they have one, to make sure that, even if their means are modest, they have a plan in place for whatever may come.
And let's talk about that, because you go to work and a lot of companies will offer a life insurance. You sign up for medical, dental, vision, hopefully, if they have it, and life insurance, some of the bigger companies. But I don't think people think about tying that to maybe they had a child and they had a will drawn. And then how is that affected if you keep it separate? Something does happen to you. You have a life insurance product and you have a will, but how do you guide people there? Is there a document to connect everything together?
Well, that's a very good question. We sort of take a holistic approach. And in the estate plan, we absolutely take a look at all of their assets, how they're titled, look at their life insurance policies, their IRAs and 401ks, and see how their beneficiary designations are. Because you're right, those assets that are specifically designated to go to someone or are owned jointly with someone else, they're going to pass outside of the will. So we can have the best laid plans in the will, but if we haven't put an eyeball on the assets and made sure that the way assets are titled and owned, the way beneficiary designations are set up, are consistent with and working in concert with the documents, then you're right. The intended outcome sometimes cannot be achieved. So that's also, really another crucial part of getting the estate plan in place is making sure that the asset designations and beneficiary designations are consistent with.
I imagine there's a lot of fragmentation going on there because, I'm middle-aged. I'm older than you all, but I'm fragmented.
In our world, you were quite young.
Well, thank you. So I do want to talk a little bit more about that. We do have to take a quick break, but when we come back, I want to talk more about exactly what we just started talking about, all that fragmentation and getting that together into a nice, well-thought-out plan. Hello, I'm Jean Pete, and I welcome you back to our show, Better Living. Better Living is brought to you by the Homestead Hope Foundation and is sponsored by Homestead Hospice, where commitment to education and premier hospice care helps patients and families through life's most important journey. Thanks for staying with me. I am still here with Chris Brannen and Paul Black. Did I get that right?
You did.
Because yes. I don't have my glasses on. I can't read. And we are talking about elder law, estate planning, wills, trusts, advance directives in the first half hour. We just started to delve into the importance of not having plans fragmented. For instance, I'm a middle-aged woman. I have a life insurance policy with my company. I also, 17 years ago, created a will when I had my first child. Since then, divorced. I don't think I've looked at the will since then. I got to look at my life insurance, but everything's fragmented. I clearly need you all. And I'm thinking $1,500. I don't know if I can swing that this month. I'll put you off till next quarter. But I don't think I'm alone. I think that's probably very typical. So I want to help educate folks for what they can do and what they should do and why that's so important. During the break, we were talking a little bit about a scenario with Paul and Chris. So first, I'm going to start with you, Chris. Can you address that, and can we give an example so that we can motivate people to get their estate in order to help them?
Absolutely. So when we're meeting with our older clients and we're thinking through their estate plan and potentially care costs, the benefit programs that we talk with people about are Medicaid benefits for nursing home, or aid and attendance for VA aid and attendance for assisted care or home care. And both of those benefits and the entire conversation is very specific as to what their assets are and how they're titled. So on the front end for us, and this carries over to our estate planning clients, we do a really comprehensive sort of fact-finding portion of the engagement where we're let's see your bank accounts. Let's see your life insurance policies. Getting very specific and digging into those. With older clients, they may not have looked at their life insurance policies in literally 20 or 30 years. Their spouse may be deceased, and our estate plan and everything we're planning to do, could be thrown off by this one little detail of a deceased spouse listed as a beneficiary on a large life insurance policy. So there again is the fragmentation that you're talking about. Let's review everything. Let's pull everything back out. Let's talk through what the options are with those things and make sure that everything is working together. All the documents, all the accounts, how they're held. And just to walk it back a little bit, all the documents that we've talked about doing, the durable power of attorney, the advance directive, and the will, they're all revocable. And they're all, you can amend those documents and change those documents. So for you, when you did your estate planning when your son was younger, as you've gotten older and your son is becoming an adult and maybe other situations in your life are changing, there is a need to change and update those documents.
Absolutely.
So, start young. We want people to start young with their planning, but also know that these documents aren't permanent. You retain the ability to change your mind about who your agent is for healthcare decisions, who your agent is for financial decisions, and how your property is distributed. So,
now let's just finish that scenario. What happens with that person who hasn't looked at their life insurance policy in 20 years and their spouse has now, who was listed as the beneficiary, passed before them? What happens with that life insurance policy?
So when we're working with an older client who has a deceased spouse, we have, let's just say we have everything set up to go to the 2 adult children, but the family never got around to checking on the beneficiary on that life insurance policy. The beneficiary on the life insurance policy is the deceased husband. So when the mother passes away, the family takes the will to the probate court, goes through that process. They submit a death certificate to the life insurance company, and the life insurance company, they want to issue a check to the deceased husband. When the deceased husband is not alive to receive that check, then the family's got to go back to the probate court and open up an estate in the deceased husband's name so that there's actually a legal representative to receive that check. And that's just one example.
Mm-hmm.
Another example will be when we're planning to help people become eligible for Medicaid or VA benefits, they are asset specific. If someone is the beneficiary, if we help someone become eligible for Medicaid or aid and attendance, and then they are the beneficiary of a life insurance policy that we didn't know about, there's cash coming into their name, into their estate, and that can interrupt benefits as well as prevent the estate plan from functioning in the way it was intended to.
And I just want to touch on that again. Alzheimer's is I've had a lot of experience with it in my work and in personal life as well. The day you get a diagnosis or a loved one gets a diagnosis, a parent, a brother, a sister, I don't care who, anybody you know, the day they get the diagnosis that they have Alzheimer's, if you don't already have estate planning in place, that's the first next appointment that you need to make, because there is a look back, right? So you got to get your assets in order, because otherwise you have to spend down all your money, and the likelihood is it's a debilitative disease, it's a long journey, it's a long battle, and a large percentage of folks with Alzheimer's or some form of dementia ends up in some type of a assisted living facility, memory unit, or skilled nursing facility. And you're going to be paying out of pocket for that unless you spend down all your money and qualify for Medicaid. And there's a look back. It used to be 3 years, 5 years?
It used to be 3 years, and as of the Deficit Reduction Act of 2005, there's now a 5-year look back period.
Okay.
And to give you a really concrete example of what that means, let's say a client, let's say someone like, my father. My father is a 66-year-old. He served during wartime in Vietnam. Not in Vietnam, but he was an active duty officer training soldiers at Fort Bragg and Fort Bliss. Because my dad has at least 90 days of active service during wartime, and because he requires a lot of help with his activities of daily living, he will qualify for aid and attendance from the VA, but he can't have assets. In his case, he's had to spend all of his assets down over several years for his care. His mother's estate has a tiny bit left. That's going to go into trust, and there have to be at least 5 years between when those assets are transferred into trust and when he is able to qualify for Medicaid in the future. And we talk to a lot of families who have what we call, a Medicaid crisis, where, mom or dad or someone else has very recently had a big health event, a stroke, or they've had rapidly progressive dementia. They need nursing home care yesterday. When families come to us earlier, as you said, when they have a scary diagnosis for someone in the family, the planning options they have are, frankly, far better, and they can be far more proactive. Most families who come and see us for long-term care planning, I would say 80%, they have not planned in advance. They come to us in a crisis state. At that point, their options are much more limited. Time is a lot more crunched. And
a lot more money is going to go to these facilities.
Absolutely. And families these days, they have a very tough choice. Do they spend down almost everything that mom or dad has to pay for care? Or do they do something to try to educate themselves about what their options are? What can we protect? What can we put aside? And it's no surprise that most families, given that option, do want to speak to a good elder law attorney and do want to know what their options are. They're not going to get any pressure from us about what to do. Our job is to be very straightforward, to educate them about their options and give them time and space to decide what, if anything, they want to do.
So what do you recommend that people do to protect their assets? Because nobody wants to think that this is going to happen to them. And we have talked about a dementia diagnosis, and sometimes that can be 10 years. So if you can get that done early, then you can be smart about it before you end up in a facility. But a lot of times with a stroke or a car accident or something else, whatever, you don't have the time to do that. So what do you recommend that families do with their assets through you all to protect themselves should something like this occur?
Well, there's no silver bullet. There's no single answer to that. It's all dependent on the facts of the situation. The planning tool that we use to protect assets, the majority of the time, is an irrevocable trust. Depending on the facts of the circumstances and the situation, there may be some variation in how the trust is worded. But what we're talking about here is specific benefit programs that are available to help pay for nursing home care or assisted living care for seniors, and the eligibility rules are specific as to income and assets. So if we can put assets into a trust to be managed by other family members, then we can potentially shield those assets from being countable in the eligibility criteria. In addition, you said this earlier, but just to kind of close the loop on the conversation, most seniors get Social Security benefits. Those seniors get Medicare. Medicare only provides a very limited coverage for nursing homes. That's sort of a wake-up call for people when they find out that their Medicare only covers skilled rehabilitation in the nursing home. There's no long-term care coverage. Nursing home care private pay around Atlanta is, I would say, between $6,500 and $9,500 a month. And that's quite a bitter pill for the family to swallow, to find out, oh, hey, by the way, Medicare runs out next week. We're going to give you a bill for $10,000.
Or you have to leave.
Yeah, or you have to find
and people don't
an
realize
alternative.
That. No matter how sick you are in a facility.
And so for those families, we usually are talking about Medicaid. Mm-hmm. And it's not just about a specific plan or a specific type of trust. It's really about education. Here's how Medicare works. Here's what it covers. Here's how Medicaid works. Here's what it covers. Here are our options, or your options, and here are the advantages and disadvantages of those options. Medicaid, in addition to the income and asset eligibility criteria, has they have a transfer of asset penalty, which is the look-back period. So if you give away an asset in the preceding 5 years from your application for less than fair market value, then you're going to be penalized, and your Medicaid is not going to make any payments on your behalf. So, navigating within that 5-year look-back period, with the VA rules regarding aid and attendance, navigating those rules to see what we can protect in a trust, which benefit is the most beneficial for the family, and thinking through every alternative. Why are we doing this? What potentially may be a disadvantage of this? And really, it's an education process, because it's no secret that our healthcare system is confusing, and add to that confusion the stress of a traumatic family event like mom or dad or husband or wife falling, and then add to that the financial strain of $10,000 a month, open-ended commitment for care. So,
or having we see a lot of adult children who are well into their 50s or 60s, one of whom is often a full-time caregiver for mom or dad at home, and that's exhausting. And Chris mentioned the H word earlier. I want to come back to that. No attorney can do everything for a family. We don't have a magic wand. We do a lot of planning, regarding assets and getting benefits. What we also do is connect those families to a larger set of resources. We're part of a larger community. We work with geriatric care managers. We work with social workers, with counselors, with home health care companies, with moving companies, all of whom specialize in serving, in many cases, seniors or disabled clients. And it's really important to our practice, to kind of our values as well, that if a client or their family has a need, that we be able to connect them to people who can help meet that need. And without that larger set of, I'll call it a team, without a good team of people to educate a family about their options, most people will stumble through this process exhausted, overwhelmed, and uncertain. And the alternative is to, come talk to us or to, a good elder law attorney, find out about your options, arm yourself with the facts, and then you'll be able to make decisions from a more informed place.
And that's so true what you said about having a team of people. And I'm so blessed to have this radio show because I get to know these teams. We've had folks on who specialize in senior moving and geriatric care managers and you all and private duty agencies and all of that. But if you're out there in a crisis with your family and you're just going through the yellow pages trying to figure out, I need to get help. You all are in this day in, day out, dealing with these people and can give choices. I'm sure you give 2 or 3 names or whatever, but you have faith in your wider casted net of people that can help in all different situations, and then you all work together to do what's best for your clients. And that is so important. That comes free with the price they pay for the estate planning, but you can't put a price on that.
And I'll brag a little bit. She's not here today, but Chris and I, as of December, hired a really fantastic woman named Melissa LaBeouf. She has about 20 years of experience in senior care. Chris and I already had a good network of all different, people who work with seniors and their families. Melissa has been really awesome to work with because there's not a single need that a family can have where she won't be able to tell them, here are your options. Here's the short list of whom I would contact. And it's really exciting for us to be able to offer our clients, and those families even more. And that's, I think that's really essential for families because I'll call it hard and soft. The hard tools of estate and incapacity planning, the documents, the tough conversations, sometimes retailing assets, those are important. The care needs often have to be met at the same time or even first. And so knowing where to go is huge.
Right. And there's some protection in that as well because they are good, qualified, credentialed companies that y'all have been working with several families, and you know what you're giving out.
And we know whom we would use personally, or in some cases with my dad here in Decatur, whom I have used. And so we can make very very informed recommendations about, what home healthcare companies, should I look at? Or is there a financial advisor or CPA who will work patiently and ethically, with a senior whose needs may be totally different than a typical client?
Yeah, so important. So we talked about a little bit about advance directives. We did touch on it, but I do just want to reiterate it again. Think thoughtfully about who you put in charge of your financial assets, but secondly, who you put in charge of your healthcare decisions, because oftentimes those two people should be different. That healthcare decision maker, should you not be able to make decisions, has to be able to fulfill your wishes. So you have to let them know what your wishes are, and you have to know that they have the emotional capacity, no matter what their beliefs are, to follow your wishes. That's not always the person that's closest to you. My sister has told me, I want to be on machines. I want to live. I don't want to go anywhere. I want to be hooked up. I said, don't put me down as your healthcare proxy then, because I can't stand to see it, and I will want to pull the plug. I can't bear the thought of that. I am not the right person to be your healthcare proxy. We've had those conversations. Have those conversations with your families. And not only that, because of my experience in healthcare, I'm trying to help family emotional situations that I've seen in the past. When you do decide what your wishes are and who is to follow your wishes, communicate what those wishes are to as many people as you can, especially the ones that are important to your healthcare proxy. Because should something happen to you and they have to make those decisions, there's nothing worse than feeling guilty or feeling isolated from the rest of your family members because they don't want you to do what you want to do, which is fulfill loved ones' wishes. So it's a tough one. It's tough conversations to have. You are giving your family, your children, your siblings, whoever, a gift of peace because they're fulfilling your wishes.
I actually want to speak briefly about other really vulnerable groups whom we serve. Chris did a presentation with a CPA whom we know and trust called John Dies. And a lot of our clients are widows or widowers who are later in life. They are incredibly vulnerable because they may have adult children, they may not. They may not have the people, even they can, close friends who are able to make these decisions. That is so if you find yourself, in the words of another advisor here in town, suddenly single, having these conversations with an attorney about who's going to make these decisions, super important. Another very vulnerable group, and I've had quite a few clients who are in this category lately for estate planning, they're recently divorced. All of a sudden, your old will is invalidated here in Georgia by divorce, but who's going to make those decisions about health care or about your finances? Who's going to take care of your kids if you can't do so? And then a third category, here in Georgia, the state law does you no favors if you are gay or lesbian. And if you don't have very basic planning documents in place, the financial power of attorney, the advance directive, your partner or your spouse may not be able to make these very tough decisions. They may be made by family who you may have a good relationship with them, you may not. So for those three groups, not only, the older clients, the disabled clients, but also people who are, suddenly single or divorced or, any client who's gay and lesbian, get those incapacity planning documents in place because not having those leaves you, in a very uncertain place if anything should happen.
Thank you so much. I do want to get your contact information out before we run out of time. So if you could just let folks know a website, where you're located, phone number, so people can contact you. Hopefully we've motivated some folks to get some estate planning in place today.
Sure. And Paul and I have an office in Decatur and an office in Dunwoody. You can reach either of us at 770-854-0688. Our website's georgia-elderlaw.com. If you want to email Paul or I, it's either Chris or Paul at georgia-elderlaw.com. We'd be glad to have a conversation with you. Not everyone is a good fit to be a client for us, but we're happy to have an initial conversation with people. If you are a good fit, get you set up with the documents and the planning that you need. If you're not, maybe you just need a referral to a different type of resource. So we try really hard to take care of our clients, and we try really hard to steer people in the right direction, even if that direction is not to us.
Thank you, Chris. Paul, any parting words?
We love what we do, and for better or worse, there's so many of us right now in the U.S. who are aging. I can't go to the grocery store and not, find someone in front of me, I'm like, she's older. Does she have good planning in place? Is there someone taking advantage of her? And at the risk of sounding cheesy, I think about my parents, their situation. They're both in a stable place and, in assisted living facilities, where their needs are met. But we've worked really hard to get them there. A lot of families we talk to are in the dark about their options, and helping people learn of their options, get a good plan in place. It's what we do, and we're happy to be of service to families who want to work with us.
And the what if can ruin a family. So preparing for the what if, it is worth it. I know it's hard to get rid of money for documents. It really is. But that what if, I've seen it over and over again. It is debilitating to families, and some families don't ever come back from it. So thank you, Chris. Thank you, Paul, so much for being with us. Again, I'm going to give you their number in case we've motivated you today to get a plan in place. 770-854-0688. Again, we're speaking with Chris Brannen and Paul Black of Brannen Black Attorney Law Firm. And again, we just touched the surface. We talked about advanced directives, a little bit about durable power of attorney, wills, living trust. We didn't really go into the differences between revocable and irrevocable and all the other things that we need to look at. So I hope you've been motivated today to get a plan in place so that you can live the rest of your life better. I'm Jeannie Pete. Thanks for listening. Have a blessed day and week ahead. And listen here, same time next week and every week. Homestead Hope Foundation is your resource for a healthy life. God bless.